Hi, good afternoon, everyone. Welcome. This is Rajiv S. Khanna from immigration.com, the law offices of Rajiv S. Khanna, PC. Today is August 18th, 2022, and this is our Thursday community conference call, which we do every other Thursday. We've been doing it for almost 20 years, maybe a little bit more. And all the conversation is subject to the disclaimers you heard when you were logging in. No attorney-client relationship. We give the best information we can based upon whatever time we have here. So, etc., etc. You've heard those disclaimers. So what I'll do is, like I normally do these calls, first I will go over the questions that I consider are frequently asked questions. Each time I answer one of those questions, I will invite any follow-up questions that you have on those issues. After that, we'll do a round of regular questions, which are posted. And if time permits, then we'll take on more questions. My hard deadline to stop is 1:30 p.m. Eastern Time. It is now 12:30 p.m. So let's get started. I have the recording on. So the first question, which I have answered so many times in the last 2 weeks, is about changing employers when you have an October 1st activated H-1B. What happens? Can I change employers? So first let me lay out the law and policy as we understand it today. Government believes if you receive an H-1B approval through employer X, you are okay as long as employer X does not revoke their approval or send in a request for revocation before October 1st. If they send it after October 1st, you're protected. You still don't have any lottery problem going forward in future. But if they revoke your case before October 1st, then you are back in the lottery queue. So first of all, what do you do if that happens? If you have still time left on your OPT, you can contact your school immediately. If you present to them the evidence that the case has been withdrawn, they will reinstate your STEM or even the first year OPT. Okay? So first thing to do at that time is to just contact your school. Many employers are saying, well, look, we had unusual business circumstances, but we are not going to withdraw your H-1B. So what do you do then? Well, then you're okay. You can even apply for a transfer today, before October 1st. There's no problem. Do I need pay stubs? No, you do not, because your job has technically not even started yet. That was going to start in October 1st. And by the way, there is a misunderstanding amongst many people that a certain number of pay stubs is required to transfer an H-1B, either the regular H-1B or a lottery-based H-1B. There is not really such a requirement. The requirement is that you have maintained status. And for H-1B, one obvious proof of your status is your pay stubs. But what if your employer is not paying you? You can still demonstrate that you worked and you subsequently took some action against the employer. You should be okay. So therefore, don't think that any specific number of pay stubs is required. You can file for your transfer even before October 1st, as long as the employer is not going to revoke. Employer X, who's petitioned your H-1B, is not going to revoke your H-1. Okay. Now let me go over these questions. I actually combined two posts here. The first post was, I'm currently on F1 STEM OPT. H-1B got approved this year. Current company is shutting down, moving to Mexico. Last date of working is 31st October. So then you are fine, because you are going into the fiscal year of the government, which begins on October 1st. And that makes you exempt from the H-1B quota forever and ever and ever. Okay. How soon can I change my employer? You can change your employer even now if your Current employer won't revoke before October 1st. If you are nervous about that, you can file for a transfer after October 1st, any time at all. You do not need any particular number of pay stubs. Don't worry about that. Okay, so that was the first set of questions. The second set of questions was from user need advice H1, who said from last week they had a set of follow-up questions. I'm on F1 student visa, got through the lottery, employer A filed for my H-1B and approved. Offer from employer B, they have applied for change of petition transfer, also approved. Questions. On October 1st, I would like to start working for employer B. Is it okay to start to work for employer B? The answer is only if the employer A does not revoke your H-1B before October 1st. But if they do it on or after October 1st, you are fine to start working for employer B. Can I give notice to the employer before October 1st? Well, then what if they send in a request for revocation? Then you have a problem, right? So just if you understand the guidelines that I've just given you, so if they don't, the old employer doesn't revoke your H-1B before October 1st, then you are okay to apply for transfer and give notice anytime you want. Okay. Now, one thing you need to remember, and this is another, not a misunderstanding, but doubt in people's minds. So you have two employers, employer A and employer B. Both, employer A got your H-1B, lottery or non-lottery, doesn't matter. Then employer B applied for your H-1B transfer. The transfer gets approved. Now, does that transfer negate or nullify the existing H-1B? Not at all. You can continue working with the existing H-1B if you decide not to change employers, or if you decide to join 1 month or 2 months or 3 months later. So the subsequent H-1B approval has no negative effect on the existing H-1B approval. If anyone has any follow-up question on this, press *5 on your phone. No new questions, please. Only follow-up questions. *5. Okay. There being no questions, let's move on to the next frequently asked question. Okay, this is another one where it is a fairly frequently asked question, not as much as the first one we talked about. So what happens if my I-140 is approved and then revoked? The answer to that is it depends on a couple of things. First of all, the regulations changed in your favor on January 17th, 2017. So if the revocation occurred before January 17th, 2017, chances are you might have lost even your priority date. On January 17th, 2017, the laws changed, and now the rule is, not the law, but the regulations. The rule is, if the moment your I-140 is approved, the priority date is yours to keep. And there is only one exception. I'll come to that. So you keep your priority date the moment the I-140 is approved. Second rule is, if the I-140 stayed approved for 180 days, you also have the right to extend your H-1B and your spouse their H-4 through any employer in the United States. This is true even if later the old employer, revokes your I-140. So there are two different rights. Right to keep your priority date the moment I-140 is approved. Right to extend H-1B if the I-140 stays approved for 180 days. So this is a protection even if the employer revokes your H-1B. Only one exception. Unless the government goes back and finds that there was fraud or some serious legal error they had made in approving the case, You keep your priority date, you keep your right to extend H-1B. But the revocations before January 2017 are very difficult to ascertain. If you look at my older blog entries, a few years ago we discussed these issues. Government flip-flopped so many times. Sometimes they said, oh yeah, you can keep your priority date even if the employer revokes. Then there came a period of about 1 year in which they said the priority date cannot be kept if the I-140 is revoked by the employer. So they flip-flopped on it. So if your I-140 was approved and revoked before January 2017, you could have a problem. And I think it might be something that your lawyer should look at. Maybe it's something you can litigate. But after January 17, on January 17, 2017, the regulations changed in your favor. So the first question is, I-140 was approved, moved back to India, and then they withdrew after 200 days in 2011. So that doesn't matter because your revocation occurred before January 2017. You filed for your request, automatically revoked, sure. Now I got my H-1B renewed through a new employer, came to the US to start the green card again. I believe I have to go through the entire process. Yes, you do, starting from PERM. And the priority date portability is uncertain, as I said. I don't think government is going to go easy on that, but who knows? All the questions are about keeping your priority date. So I don't think it's that clear cut that you can keep your priority date. So Manojji, all of the questions are about keeping the priority date. I think you may not be able to. Okay. Star 5 if you have a follow-up question on this. No new questions. Anyone has a follow-up question on this, press star 5. Okay. Let's go on to the next frequently asked question. So I don't know how many of you know this, but in H-1B and green card processes, there is a certain wage that has to be paid. That much everybody knows. But you can use different wage sources other than the government source. That's called alternate wage survey. So this question talks about what is the impact of an alternate wage survey for H-1B LCA, and this is also true for green cards, PERM-based green card. And the second part of the question is about AC-21 rule when the company is bought by a successor-in-interest. So I'll talk about that in 2 seconds. But first, let me lay down the ground. So you can't just use any wage survey to convince the government that your wage survey is as good as the government's own. I think there are about 10 requirements that the wage survey must meet. I'm trying to remember if it is 10 or fewer. I think it's 10. Some of the requirements are, for example, the survey must be conducted by a reliable third party. The survey must not be more than, I think, 2 years old. You should be using the most recent copy of the survey. It must have a significant statistical pool from which the survey was conducted. So there are all these requirements. So now this member of our community wants to know what would be the impact of this, because my lawyers are using Willis Towers Watson General IT report. So we have used Towers Watson before. It's should be acceptable. Of course, I'm sure your lawyers would have looked at whether it meets all the requirements that the Department of Labor expects us to meet. What kind of RFE we could expect? Actually, if it passes muster with the Department of Labor, it probably will not be questioned by the USCIS. So I think you should be reasonably safe. Now, you want to know what is the success rate of H-1B extensions. That's very difficult to predict because remember, just because you have an H-1B approval does not guarantee subsequent approvals. Based upon the same case, government can still deny you. So that's very difficult to predict. But there is a policy statement from the government that normally we don't disturb our findings. If we have found somebody approvable first time, it's not likely that we'll find them non-approvable next time, but certainly we can do that. So the possibility exists that H-1B can be denied, but not based upon Towers-Watson if your lawyers have looked at the admissibility of that wage survey. Okay. Is it a recommended practice to use alternate wage surveys? I usually don't, because it creates another variable in a situation which has already so many variables we don't like them. But we have used them, and we have used them extensively, especially during the time when the government tried to jack up the prevailing wages. So usually there's a few percent point difference in the private surveys and the government survey. The next question is about AC-21, change of company. So this is something also you folks need to understand. It's a fairly lengthy, fairly detailed piece of information. I'll try to summarize it. Normally what happens is, if your company gets bought over, whether in whole or in part, in a certain legal way, the next company that comes in can continue your green card and your H-1B process without any problem or disturbance. They might have to do 1 or 2 additional filings, but it doesn't really disturb the process as a whole. Okay? So successor-in-interest, it's a term of art. It has a certain meaning. I don't want to go into that, but because it's not directly relevant to this question. So let's say we've got a client here. The company is getting sold and they have 45 employees. All of them have I-140 approvals. Some of them have 485 pending. What am I going to do with these cases? So I would divide these cases into 3 categories. I-140 approved, 485 not yet filed. I-140 approved, 485 pending less than 180 days. I-140 approved, 485 pending more than 180 days or more. So the third category is easy. If you're eligible for AC-21 portability, you don't have to file the I-140 again. In the first case, where you are not yet eligible to file your 485, I have no choice but to refile the I-140 with the new company's name and ask for an amendment of the H-1. Okay? So the reason we avoided it, 1 is the expense, 2 is the uncertainty, and 3 is the time delay. Okay? So where we can do portability, we do portability. But for that, I-140 should have been approved, 485 pending, 180 days. What if you're 20 days away from 180 days? I would probably wait those days out and then file AC-21 portability. Okay? For those cases where it is less than 180 days, like I just discussed, if it is close enough to 180 days, I think we are reasonably safe waiting. But if it is maybe 10 days into 180 days, I think we should seriously consider filing I-140 amendments. Okay. So in this case, the question that is being asked is, I-140 approved for successor-in-interest. EB2 I-485 pending for 6 months since October 2021. I-140 amendment was approved in July 2022. That's a very interesting scenario. So should you have AC-21 portability counting from the first I-140 approval or the second I-140 approval? And the answer is, I don't know for sure. But if I were to make a guess, I would have to look at the policy and see if there's any exception. The way I read this policy, I would say that you can safely count your 180 days from the first I-140 approval. Okay? I hope that that answers your question. If you move to a new company, you do not need to restart your PERM and I-140, etc. Because what you do is you move your whole green card over to the new company to a same or similar job. That's the whole idea of a portability. This is different than just porting your priority date. For that, you have to start the green card all over again. But when you port your entire green card, where I-140 is approved, 485 has been pending 180 days, you do not start the green card all over again. If anyone has a follow-up question on this, press *5. No new questions, only follow-ups, please. Okay. Let's see if there's any other frequently asked question. Okay, there isn't. So we will go back to our list of questions. Go back to our list of questions and go to the normal questions. Question number 3. So here, during the adjustment of status, they realized that birth certificate, the place of birth is spelled differently. The last few letters are Palle, as in P-A-L-L-E, but in the birth certificate or passport has Palli, P-A-L-L-I. So passport and place of birth in the certificate of birth certificate are different. Now, I don't think this is a major issue. Okay, I don't think this is a major issue. I think this is fine. Because remember, one part of the problem is that we do spell names phonetically. So the name Rajiv, which is my name, can be spelled with a R-A-J-I-V, which is what I use, or R-A-J-I-V-E, R-A-J-E-E-V, R-A-J-E-E-V-E. There are so many ways to spell that. They're all right, because basically we are translating from Hindi or whatever local language we have onto English. The only difference between people's name and places name, the places names usually have an official spelling in English. But even then, I don't think this is going to be a big deal. Okay. *5 if you have a follow-up question on this. *5. Okay. Next question is question number 4. This is wants to learn more about H-4 and H-4 EAD for spouse. STEM OPT for spouse is expiring on Jan 5th next year. Visa expired June 2022. I've got my H-1B approved last year, submitted PERM, hoping to get PERM LCA approved, and then planning on going for I-140 premium. Can my spouse apply for H-4 plus H-4 EAD now? No. Not until the I-140 is approved or there is another condition which you don't meet. So the answer is no, you cannot. If he applies for H-4 and H-4 EAD now, will he be able to stay in the USA after his STEM grace period? Yes, absolutely. Can't apply for H-4 EAD, but can apply for H-4 and can stay. And I don't see any other option to avoid the employment gap other than curricular practical training. Okay. *5 if you have a follow-up question on this. *5. Okay, this one is from area code 813. Let's see, and that's in Florida. Okay. Florida, go ahead. I can hear you.
Hi, Rajiv. Thanks for taking my question. This question is related to automatic revalidation. So
no, that's not related. Sorry, that's not related to this, is it? That's a totally different issue.
I mean, H-4 EAD extension, I thought like...
okay, well, we'll make an accommodation for you. Go ahead. So you are thinking of using AVR to do what? Go ahead.
Yeah. So her H-4 EAD is expiring soon, September 14th. And she's planning to travel to Mexico on September 10th. And our current I-94 is expiring on September 24th. So while coming back to US, I heard like some CBP officers, they never heard of these automatic revalidations, and they're not giving, they're not extending I-94. So what kind of resources we need to bring? Okay. I mean, we need to carry to prove we have this rule and...
Yeah. So I discussed that problem earlier during the conference. Customs and Border Protection is very ill-educated. Here is the problem. What you want is, when you come back, you want your I-94 extended all the way to the approval of the H-1B. Okay. What happens
Yeah.
is CBP is saying no, you have to apply for an H-4 extension with the USCIS, and that is not true. If the visa is valid, the H-4 visa is valid, the extension should be given coextensive with the H-1B approval. However, when you are using AVR, that's where the law becomes very uncertain, because technically AVR is allowing you to re-enter the United States based upon your existing I-94. They don't want to give you a new I-94. So what is the solution? One possible solution is, don't use AVR, travel beyond Mexico, Canada, go to Bahamas. When you come back, now you are no longer covered by AVR. They have to give you a new I-94. The question is, at that point, will they give you an I-94 coextensive with your visa or with the H-1B? And my suggestion is H-1B. Make sense?
Mm-hmm.
Okay.
Sure. So can she travel alone, or do I need to accompany with her?
She can travel alone, unless for the moral support. Otherwise, there's no problem.
Oh, okay. Yeah.
Okay.
Sure. Thank you, Rajiv.
You're welcome. Good luck. Okay, I think that question is covered. Let's go on to the next question. This is question number 6. O1 visa to EB1A. So I want to make this clear. There are 3 kinds of visas when it comes to intention to file a green card. H-1B, H-4, L-1, L-2, there is absolutely no problem. You can file a green card while you are on these visas. This is clear cut. It is in the statute. Then there are also those where filing for a green card is clearly an objectionable activity according to the government. If they want, they can create an issue of it. For example, a student visa may not be granted if you have a green card pending. A visitor visa may not be granted if you have a green card pending. A TN may not be granted or extended if you have a green card pending. So there are those. Now even here, the government can make exceptions. Personally, I came to the United States on student visa while my green card was still pending. And the government did make an objection. And I did explain to them what I do. And they agreed. They said, okay, we can approve your student visa. We believe you. Okay. And then there's a third category where the language is kind of fuzzy and it's difficult to figure out what they are saying. O1, E3 visas, which is the Australian equivalent of an H-1B, these tend to fall in that category. However, in my view, having filed a green card is no ground for denial of an O1 or of an E3 visa. So if you want to study this further, you can go to a publication called Foreign Affairs Manual, which is a publication of the State Department, and go to volume 9 Foreign Affairs Manual, and read under O1. Okay? Any questions related to this? Any follow-up questions? Press *5. No follow-up question. Let me just lock our conference because people are still logging in and we may not have time for everyone.
The conference is now locked.
Okay. Next question is from Abshu, number 7. Employer filing AOS 131 I-765 together. So what is happening here is his adjustment of status is being filed by the employer and he wants to file for his wife himself. Can he do that? And the answer is sure. Why not? But if you had the money but not the time, I would say get a lawyer. However, if you feel that you want to save the money, then go ahead and do it yourself as long as you follow the instructions on the USCIS website. Make sure you follow the instructions on the website. Form instructions can be old. you should be able to file the 485 yourself, okay? But you have to wait for the receipt for your case. As far as I know, although a part of me thinks that you should be able to file it even without the receipt because it's the same I-140, I think it's still better to wait for the receipt to come. That's the way I see it. I can't really tell you off the top of my head whether that has any other issues, but I think it's much better to wait for the receipt. Any critical issues? Yeah, just be meticulous. Make sure that whatever evidence they ask for has been attached. Make sure the proper fees is attached, and make sure you're sending it to the right address. On a different note, as a licensed professional, can I start my own professional practice after I receive my green card? Sure, you can. But how soon? That question is the same as asking how soon can I leave my employer after I get my green card, and that is already in our frequently asked questions. Go to immigration.com and review that. Star 5 if you have a follow-up question on this. Star 5. Okay. So let's see. This is area code 813, which is also Florida. Okay. Yeah, Florida, go ahead, please.
Hi, Rajiv. I'm the person who posted that question. So I think you answered my first part, which is can I start my professional practice? But I guess question is, can I register with a small business administration as a DBE? Because I was reading somewhere that you need a citizenship to be registered for that. So I was just curious if you have any feedback on that.
Beyond my current practice. I used to do SBA practice, but this is beyond my current practice. I have no idea. Sorry. Okay.
Okay. Thank you.
Good luck. Next question, which is question number, let me see. Yeah, got that. Question number 9. Will there be an issue while working remotely on F1 STEM OPT? Well, you should contact your school, your DSO, okay? 2 years ago, ICE, which is in charge of students, Immigration and Customs Enforcement, they are in charge of students' affairs. They put out a memo, and I'm quoting from memory, don't hold me to it, which said during the COVID times, we are going to make an exception that you could actually do your STEM OPT also remotely as long as you are being adequately supervised. Okay. So the answer to that question is, if that memo is still in force, and I think it is, get together with your DSO, see if you can grab a copy of that memo. Of course, it's publicly available also. Then obviously you are okay working remotely. If that memo is no longer in effect, or if it goes out of effect, then you would have to return to working on site. Okay. Now, working from India is even more complicated, and they might have another option there that if you can report to the India branch of the company and be supervised there as well, that could work. But the key here is that memorandum which ICE had put out in the initial phases of the COVID-19 epidemic. And then they renewed it the following year, and I think it's still good. Okay. So, but if you take paid time off, etc., or unpaid time off, etc., I don't know if that counts as your days working on STEM OPT. Is there any time on max number of visits or max duration of a visit? As long as you're maintaining your OPT and the number of days you're supposed to work, there is no maximum limit. Okay. Star 5, if you have a follow-up question on this, press star 5. Okay, let's see. This one is from area code 928, which is Arizona. Okay, Arizona, go ahead, please.
Sir, I have posted this question. So currently the work is completely remote. So like my team is working remotely, like distributed across the US and working remotely. So my question is that if I work from India, and as you said, that memo that you were talking about, I have already referred it. It says that the 5-month rule has been suspended.
Hello?
Hello?
Yeah, I can hear you.
Yeah. So it says that the 5-month rule has been suspended for staying outside the US during the OPT period. And I also see that even if the 5-month rule is not suspended, then I still have around 5 months absence allowed outside the US. So I just wanted to make sure that, let us say I take a 2 months.
Well, first of all, it's not
I take a 2 months.
it's not 5 months. Hang on. I think you are misunderstanding the rule. It isn't 5 months. It's a certain number of days, and I don't remember how many days it is. Just make sure it's, because see, I'm trying to remember what the regulations are. The first year of OPT, you're allowed to be out of work for what, 60 days or 90 days? 90 days, yes, right?
Out of work is 90 days. Yes.
Yeah, and on second and third year, you're allowed to be out of work together 60 days. And you can combine the two to 150 days if you have not used them, right? That's sort of the way the regulations read, if I remember correctly. So that comes to 150 days, not to 5 months.
Year.
That's not 5 months, that's 150 days, right?
So I'm in the first year, and this is not about unemployment. It's just about absence from the US.
Okay. I haven't read the memo for a while. I read it a couple of years ago. So I don't know what the memo says. I would say take the questions to your DSO. They have the most latest information. And also be careful. I'm not sure how long this COVID exception is going to be kept in effect, because as you know, rightly or wrongly, people are returning back to work. So I don't know how long this is going to last. I would have you check with your DSO, because they also receive various informational emails, etc., from ICE on an ongoing basis. Check with them what they say. You can always come back here and we can double check this with you. Okay. Good luck.
Got it. And another related question is, can the employer have any objection other than the status thing?
I don't see what objection they could have. They are paying you the same salary, whether you work from USA or India. I can't really guess the employer's mind. I don't really know. Unless you are also, another objection could be if you are working with export restricted technologies. So if you are working, for example, with, 128-bit encryption. Okay. So let me go on to the next question. Good luck. Next question, number 10. After I-140 is approved, company could not support CP and I-485 was not filed. The company is filing L-1B. Is it okay to get back to the US without an H-1B? So, first of all, if your concern is that coming on L-1B somehow negates your green card, it does not. So he was on US on H-1B until 2019. Extension got denied, had to go back to India working for the same company. Trying to come back, he has the I-140 EB2 approved, priority date 2010. Company does not support CP, could not file 485. The company cannot renew his H1. Actually, the company could renew his H1, but that's okay. I personally think they can. This company is filing for L1B. Oh yeah, he can file a 485 even if he comes back on L1. So just because He's coming back on L1 does not stop him for filing his 485. So 485 can still be filed, no problem. *5 if you have a follow-up question on this. *5. Okay. So this is a question about 212A7A11. Now, Wendy, I think you should talk with a lawyer who does deportation work. They are normally the ones that are most intimately involved with these kinds of waivers. I think you have two problems. One problem is at the border, they denied you admission. That's a 5-year bar. But if the admission was denied on fraud grounds, that's a permanent bar. These are two different waivers. So you need to talk with wherever you are, talk with a US immigration lawyer who does deportation defense or what is called removal defense. Okay. I have nothing else to add to that, but I see that there are two possible waivers here. All right. So talk with somebody else. I'm not going to be able to help you much with this. I would have to look at the law more carefully. But this is a potential issue that I see. Next question, number 12. I think this is the second last question. And then we can have new questions if there are any. So this question is, pending I-485 supplement J after I-485 is approved. Company A filed for 485 and I-140, downgraded in October 2020. I-140 EB3 was approved in July. Joined previous company B in April 2022. They also have an approved I-140 EB2. Company B filed I-485J for AC21. Well, your AC21 was filed for EB3 then, right? Not for EB2. So, yeah. So I think the problem here is, this is a very difficult question to answer. I can start with the resolution first. Contact your congressman's office. Ask them to double check with the USCIS if this green card is properly approved. Second thing what you can do is file form I-90 telling the government that there appears to be an error, because this is very typical. It's happened to a lot of people where they had an old employer and a new employer. Old employer had I-140 approved under EB3 and EB2 category. 485 was filed with let me rephrase that. Okay. The old employer had EB2 approved. Then you changed employers, filed green card again, took the priority date of the old green card, got an EB2 approval, filed an EB3 downgrade, and filed a 485 with that because the dates were current. Now what happened is, before you could do anything else, you got a green card approval under EB2. Now I am very suspicious of that green card approval, because you have an EB2 approval under from the old employer and also from the new employer, but the 485 was attached to the EB3 and you never asked for interfiling. Can the government voluntarily attach it to EB2? They can. They can take the 485, attach it to EB2. But it's best to double check. First, contact your congressman, ask them to double check with the government. And two, file form I-90 requesting the government that there is an error on your green card. That's the way I'm recommending people do it. *5 if you have a follow-up question on this. Press *5. Okay. Last question is, currently on F1 STEM OPT, company applied for PERM without H-1B. So if you are on the call, please press *5. I need to know which country you were born in. You are not here, or you are from the Indian origin. Okay, I saw it. I just saw that. So Indian origin, actually it matters which country you were born in. Should I stop the PERM process? Well, let the PERM process roll, because the intention issue only comes when you file the I-140. Okay, so therefore, even if you get the I-140, even if you get the PERM approval, you have 180 days to file I-140. Okay, after that PERM expires, and if you do not file an I-140, you have no immigrant intent, because the questions on all the forms ask this: have you or has anybody ever on your behalf filed for an immigrant visa? Remember, PERM is not an immigrant visa. I-140 is. So if you don't file an I-140, there is no immigrant visa application. Hence, no question of intention. So to me, it looks like a good idea to let the PERM go through. Okay, it appears that we are done with the questions that were posted. We have 15 minutes to answer new questions. Anybody who has any question, press *5 on your phone, please. Anyone who has any question, new or old, press *5. What? Just one? I am very pleasantly surprised. Okay. Area code 571. 571, go ahead, please.
Hi, Rajiv sir. I contacted you in the morning too. So the question is on H-1B. So as you already know that my company employment has ended, and after it ended, my H-1 got approved. And so what the suggestions I got from the consultancy is, if I just have that H-1B approval copy, even though the previous employer withdraws my H-1B application, still I can transfer H-1B in October. So you've already said that the current employer or the previous employer should not revoke H-1, but I don't know. I got this suggestion, and they say that if the approval copy is still there, it can be saved. So do you have any comments on it?
I never respond to questions like this. Somebody said something and you believe it to be true. That's your choice. I have nothing to say about it. Okay? Good luck.
Okay.
Bye-bye. Yeah, I don't like responding to questions. First of all, what are the qualifications of the person answering the question? Are they a lawyer? What are the basis for their answer? So it's just too complicated to get into that. You can believe what you choose to believe. Okay, so let's go back to, I have two more hands up. Let's see. This one is unknown, so it could be a voice over IP. Go ahead, you raised your hand, you logged in at 12:29 p.m. Eastern Time. Go ahead, ask your question, please.
Hello, Rajiv ji. This is a follow-up to question number 12.
Mm-hmm.
So in that question, that's my question actually. So after I received the green card approval, my attorney suggested me to continue, because this happened within a few days or a week. So my attorney suggested
Hang on.
to
Let
continue working with the...
Hang on. Let me tell you what my problem is. Okay. So you are relying upon portability, correct? To get your green card?
No, sir. Let me add to that. So I worked with I continued working with the original sponsor employer.
Okay. No, but that's not my, hang on. That's not my problem. My problem is you did not file a 485 through the old company B. You filed a supplement J, right?
Correct.
Right. So now let's look at the source of the supplement J. Was the supplement J porting an EB3 case or an EB2 case? EB3 case. Right?
It was porting an EB3 case and asking for a transfer of underlying basis from EB3 to EB2.
Well, that you probably can do. It is difficult for me to, let me think about this. If you asked for both supplement J and transfer of basis, I think you are okay. But if you were just doing
Yes, so that company did that, and sorry, sir.
Yeah, no, then you are okay. And even if they approved it on based upon company A's original application, we don't care. Because you have your ducks and drakes in row. You filed supplement J and you also asked for a transfer of basis. Okay. Now the interesting thing is transfer of basis is very common with the same employer. Can it be done across employers? I think it can be. So that is not squarely covered by their existing policy, but I think you are reasonably safe. I agree with your lawyer.
Okay. And sir, one other thing to add is since the previous employer also had the I-140 under EB2 approved, which was not revoked, they used that for the transfer of underlying basis. So it was not that they used the original 485
they would have to.
Employers.
They would have to. I understand that. They would have to. And I think in my mind, that's the smart thing to do anyway. But the only problem I have with this is that, is it really allowed across employers? We can transfer bases with the same employer, no question about that. That's very clear cut. But can we also do it across employers? And if I were to argue this case, I think it would be a winning case. I think, yes, that should be allowed as well. But is it clear cut in the policy? The answer is absolutely not. There is nothing in their policy that says that you can do this. Okay.
Okay. Sir, can I ask a follow-up question to this?
I can give you another couple of minutes, but that's it. You have a lawyer, talk with them. They're giving you good advice. Go ahead.
Okay. Sir, just a follow-up question to that is, so 485J is still showing pending. What is the normal USCIS action on that? Do they go into that? Do they keep it pending?
No. That should be approved. And that's why your lawyer is saying maybe they approved the old 485, which is okay. We don't care. You've done your homework already. Typically, the 485 should be approved. The J should be approved first, right? Because that's what is causing you to get your green card through the new employer. But because the government is in such a hurry to approve these cases, I'm not sure that really makes too much of a difference. As far as you are concerned, I think you have done everything by the book. Nothing wrong with the case. I don't think the government can say that you committed any missteps. If anything, government's own procedures are at fault. I doubt very much they're going to object to your approval. Okay?
Okay. Thank you so much.
You are very welcome. Good luck.
Thank you.
All right, folks. So that was all the questions we had for today. I will see you again in 2 weeks. Be well, and it's always a pleasure talking to all of you. Take care. Bye-bye.